I'm David Hart, Executive Vice President at the Florida Chamber of Commerce. Welcome to another edition of the Florida Chamber's Bottom Line. Our special guest today is Representative David Hood. Representative, welcome to the show.
Pleasure to be here.
Well, Representative, for the last 2 years, you've worked diligently on a very important issue to the Florida Chamber and the business community, often referred to as accuracy and damages. And I wonder if you could tell our viewers a little bit about what that issue is and how would you solve the problems you see?
Well, the cost of litigation in the state of Florida drives whether we can bring new jobs to the state of Florida, keep good jobs in the state of Florida. So when we look at the damages in litigation, we need to make sure they're true, not fictional. And so one of the problems we have with the system we currently have in the state of Florida is we're dictating damages based on fiction, not on facts, and that's what we're trying to cure. The public, the jury, everybody should be deciding what a plaintiff gets based on fact, not fiction.
So, Representative, you've probably heard about this study by the Institute for Legal Reform that consistently has ranked Florida in the bottom 10 of the 50 states in terms of our legal climate. And it's our belief that curing this accuracy and damages problem is one of the areas we need to get right to improve our ranking amongst the other 50 states. You actually practice law in this area. You've been in the courtroom on these types of cases. I'm curious what you see happening in the courtroom. Is it correct to say that at present day, juries are not hearing the full evidence about the cost of medical care?
Well, let's use a great analogy like when all of us go and buy cars. And when you go buy cars, nobody pays the sticker price. You may go buy your Ford Fusion and it has $25,000 on the sticker, but you usually offer and you walk out paying 20 grand. Well, what's happening in the courtroom is we're showing juries there that the hospital bill was $100,000 when in fact that hospital bill was closer to $50,000. So the jury is making decisions based upon evidence that's not true. It's fictional, not fact. And so what happens is that inflates the amount of verdict that they enter. As a lawyer, when you're negotiating settlements, you negotiate higher settlements because usually what you do is it's a multiple of what your medical damages are. So if we simply went to a system that we do this based upon fact, not fiction, it will by definition lower the total amount of settlements. It will lower what we're supposed to be getting, and at the same time, the people will be fairly compensated for those people who are injured by negligent individuals.
So part of your solution and your legislation would allow for, or perhaps require, that the actual cost of damages be heard by the jury. That sounds pretty common sense to me. What about another area I've heard where there's some problems, which is there may actually be some situations out there where medically unnecessary treatment occurs, and that also drives up the cost. How would your bill address that?
It says that if you're the individual who caused the injury through your negligence, then you only have to pay for those treatments that were medically necessary. It seems somewhat commonsensical to me that if you were negligent, you should be responsible for what you did. But if a doctor or somebody provides medically unnecessary treatment, you should not be responsible for that. The person who provided the unnecessary medical treatment, they should be responsible for that.
Very good. One last area I'd like to ask you about is something called letters of protection. I bet that's something a lot of people haven't heard of, but we understand that there's these instruments out there in the marketplace that are actually bought and sold often by third parties that may be causing inflation of these damages. Can you very briefly describe the letter of protection and what that is?
Letter of protection is something a doctor will take that says, okay, you can't pay me or you don't have insurance, so I'll take a letter of protection and I'll treat you. The problem is that the abuse comes in is a lot of these doctors end up charging 3, 4, 5 times what they normally would charge by taking the letter of protection. The margin is so large, there's 2 hedge funds in the state of Florida that do nothing but trade on letters of protection. And there was a study done by Publix, which happens to be the largest employer in the state of Florida. They reviewed almost 1,700 files and figured out that the charges under a letter of protection were almost 82% higher than the usual and customary charges of those doctors. That's dramatic.
So Representative Hood, your solutions are so common sense. I'm at a loss as to who would oppose this and why.
Well, it's like everything, follow the money. I think the trial lawyers, and they've got some good points, but as a general rule, it's the trial lawyers that are fighting this. The argument first was we need to make sure that there are enough doctors to treat those people who get injured as a result of negligence, but I've been doing this for 36 years and I've never seen a situation where there weren't doctors willing to treat injured individuals.
Well, Representative, on behalf of the Florida Chamber and our members, I certainly want to thank you for your steadfastness and your hard work on this issue. We look forward to working with you the remainder of the session to get this done. And to our viewers, thank you for joining us on another edition of the Florida Chamber's Bottom Line.